My name is Brian Cronin, and I'm very pleased to welcome you to this tutorial on patent claim analysis, which is based on the European Qualifying Examination 2014 pre-exam. To follow this tutorial, you will need a copy of the 2014 EQE pre-exam claim analysis questions 11 to 20 and the examiner's report. Both of these you can download from the EPO website under the captions Learning and Compendium. If you prefer to read the questions in French or German, you are perfectly free to do so, but we will be continuing the tutorial in English. Before we tackle the questions, please make yourself familiar with the client's invention and the prior art documents D1 to D4. We'll go through these briefly together. Turning now to the client's description, you will see in paragraph 1 that the present invention relates to liquid soap dispensers, which is going to be the subject of this tutorial. Paragraph 2 deals with the prior art document D1 and states that D1's tube it does not contact the base of the bottle. Paragraph 3 sets out a drawback of the liquid soap dispenser of D1, namely that too much liquid soap is left at the base of the bottle. Paragraph 4 introduces the figures. Figure 1 shows the first embodiment, figure 2 shows the second embodiment, figure 3 shows the third embodiment. Figure 4 is a perspective view from outside the bottle, and figure 5 shows a liquid refill bottle. Turning now to paragraph 5, which describes figure 1. I think it's a good idea when you read patent applications like this for the first time that as you read the description of the drawings, you write down on the drawings against the reference signs the names of the different parts that you see. So what do we see in figure 1? We see that 10 is a liquid soap dispenser, 11 is a bottle, 11A is a flat base, 12 is a hand pump with its dispensing nozzle 13, 14 is a tube, and 14A is the tube's end part. The client's second embodiment is described in paragraph 6 with respect to figure 2, which is now on the slide. What we see here is 20 is a liquid soap dispenser, 21 is a bottle, 21A is a dome-shaped part, 21B is the lowest part of the bottle, 22 at the top is a hand pump, 24 is a tube which comes down the middle of the bottle and is bent at its bottom end, as you can see in the drawing. And paragraph 6 specifies that nearly all of the soap can be removed from the bottle using this liquid soap dispenser. Paragraph 7 describes the client's third embodiment with respect to figure 3. Here, what do we see in figure 3? 30 is a liquid soap dispenser, 31 is a bottle, 31A is the base of the bottle with a V-shaped profile, 31B is a well, where I suppose the liquid would accumulate, 32 at the top is a hand pump. 34 is a tube which goes down the middle of the bottle and is bent. And 34A is the end part of the tube. Paragraph 8 shows in figure 4 an exterior view of the liquid soap dispenser. Paragraph 9 shows or refers to figure 5, which shows a liquid refill bottle with its screw cap 43. And paragraph 10 has a definition of the liquid soap compositions, water, detergent and glycerin, and it has the words "for example" and "preferably," which are words you frequently encounter in patent applications and you should always take note of in the EQE. Turning now to the description of document D1 that you'll find on page 16 of 29 of the examination papers. D1's figure 1 is shown on the slide. We can see that we have 100 is a liquid soap dispenser, 110 is a bottle, 120 is a hand pump with its dispensing nozzle 130, 140 is a tube that goes down the middle of the bottle but does not contact the base of the bottle, which confirms what the client said in paragraph 2. And remember, the client's drawback in paragraph 3 was that this D1 liquid soap dispenser leaves too much liquid soap in the bottle. Turning now to document D2, the figure 1 of D2 is shown on the slide. D2's prior art liquid soap dispenser 200. Here in the drawing we can see 210 is the bottle, 220 is the hand pump with its dispensing nozzle 230, and we can see a tube 240 which goes down through the bottle and its bottom end is bent and extends along the base of the bottle, as is confirmed in the last line of D2's description. Turning now to D3, here D3's bottle is shown on the slide. It's a different type of bottle. It's a squeezable plastic bottle containing a washing up liquid. 330 is a nozzle, 310 is the bottle, 330 is a nozzle, 340 is a tube which extends into the neck of the bottle only very slightly. The bottle bottom is domed, as we can see on the drawing, and this is stated to be for stability of standing the bottle, and it is described that to remove liquid you turn the bottle upside down and squeeze it. In paragraph 3 of D3 we find a definition of a washing up liquid. Let's turn now to D4, which is a liquid soap dispensing system. A bit more complicated because it's not only a bottle. The bottle is 410. 420 is a manually actuated pump, which we can equate with a hand pump. 430 is a tube that connects the bottle 410 to the pump 430. This tube has a vertical part and a horizontal part. And 450 is a wash basin. Now, before we go into the questions, let's just make a brief outline of these questions. So there are 10 questions numbered 11 to 20. Each question is followed by 4 statements. Your task is that you have to answer whether each statement is true or whether the statement is false. We will deal with each question and its 4 statements in turn, and for each question or group of questions, we'll check our answer and the explanations given in the examiner's report before going on to the next question. So question 11 then introduces a claim 1, which we will read together. Claim 1 is bottle for a liquid soap dispenser, the bottle having a base for touching a tube of a liquid soap dispenser. And the 4 statements that you have to ascertain whether they're true or false are: 11.1, the bottle of the first embodiment of the application is covered by the scope of Claim 1. 11.2, the second embodiment is covered by the scope of Claim 1. 11.3, the third embodiment is covered by the scope of Claim 1. And 11.4, the bottle shown in Figure 5 is covered by the scope of Claim 1. Let's deal with these statements separately. So here we have 11.1, which concerns the first embodiment of the invention, which is shown in Figure 1, which you see there on the slide. To determine whether this embodiment comes under the scope of the claim, we have to compare it with the claim. So let's run down through the embodiment and see what is there. So we have a bottle 11 for a liquid soap dispenser, yes, and indeed a liquid soap dispenser is actually fitted on the bottle. The bottle has a base 11A that actually touches the tube 14. So this statement 11.1 seems to me to be relatively clear, and I think you will also find it clear. Please answer whether it's true or false, and then we'll proceed with the next question. 11.2, this is the second embodiment of Figure 2, which is now shown on the slide. We have to make the same analysis. Here the tube does also contact the bottom of the bottle, so make up your mind whether this embodiment is covered by the scope of Claim 1, true or false, and we'll go to the next question. Question 11.3 is also relatively clear because we have also a bottle for a liquid soap dispenser. The bottle has a base, in this case it's 31A. The base touches a tube 34 of a liquid soap dispenser which is fitted on the bottle. True or false, and we'll go to the next question. Question or statement 11.4 now concerns the bottle shown in Figure 5 is covered by the scope of Claim 1, and we have to ascertain whether that is true. The bottle shown in Figure 5 has a screw cap 43 and it does not have a fitted tube. The purpose of the bottle is actually a liquid soap dispenser. The figure does not show that there is a base on the bottle, but can we assume that a base of the bottle is inherent in this figure? And we know from the description that if a liquid soap dispenser is fitted, like in Figure 1 to 3, the tube would touch the base of the bottom. But the question you have to answer is the bottle alone with its screw cap 43 covered by the scope of Claim 1, true or false? And we will go to question 12. Question 12 concerns the same Claim 1 as before, And this time we're concerned with knowing whether the subject matter of the claim is novel with respect to the respective prior art documents D1, D2, D3, and D4. So here we're talking about the function of the claim subject matter in assessing novelty. If the claim subject matter covers something that is part of the state of the art, the claim lacks novelty, and D1 to D4 are all in the prior art. So let's deal with the statements separately. 12.1, this concerns the subject matter of the claim with respect to D1, and D1's figure 1 is shown on the slide. Let's read through D1, comparing it with the claim. D1's bottle is for a liquid soap dispenser. The bottle does have a base. The tube 140 of the liquid soap dispenser, however, does not touch the bottle base. Your answer to the statement is going to depend on the meaning of the term a base for touching a tube. Does the subject matter of claim 1, is it novel with respect to claim D1? Then the answer is true. If it's not novel with respect to D1, the answer is false. And put down your answer and we'll go to the next question. We have now question 12.2, which we're concerned now whether the subject matter of claim 1 is novel with respect to D2, and D2's figure is shown in the drawing. D2 has a bottle for a liquid soap dispenser, which is 240, 220, 230. The bottle's base does touch the tube end. What do you think? Is the claim novel or not novel over this disclosure? Write down your answer and we'll go to the next question, which is now shown on the slide. Here we have the subject matter of claim 1 is novel with respect to D3. That is the question. D3's bottle is for dispensing washing up liquids. It has a domed base that is far removed from the tube 30. There is no hope whatsoever that the base and the tube can contact one another. So can we say that this bottle is covered by claim 1? How do you answer? True or false? And we will go to the next question. We now come to D4. The subject matter of claim 1 is novel with respect to D4. True or false? Here D4's figure is shown for comparison. D4's bottle 410 is for a liquid soap dispensing system, which is the same as a liquid soap dispenser. The bottle's dome-shaped base does not touch the tube 430 of the liquid soap dispenser. So is the claim novel or not? You answer, if it's novel, it's true. If it's not novel, it's false. And then we will go to the answers in the examiner's report. Here now are the examiner's answers, together with the short caption that I have added just as a brief explanation, and then we will go in afterwards to the examiner's comments and further comments on the questions. So 11.1 is true. The first embodiment is in the scope of claim 1. Likewise, for 11.2, the second embodiment is in the scope of claim 1. It's also true. And the third embodiment is in the scope of claim 1. It's also true. And 11.4 is also true. the figure 5 bottle is in the scope of Claim 1. We'll explain later. For question 2, the examiners say that all of the answers were false. 12.1 is false because Claim 1 is not novel with respect to D1. 12.2 is false because claim is not novel with respect to D2, and likewise Claim 1 is not novel with respect to D3, and for 12.4 the answer is also false. Claim 1 is not novel with respect to D4. So did you get all of the answers right? Good. Any mistakes? Don't worry. We'll discuss these with the next slide. We'll discuss first of all the possibilities of going wrong, and then we'll go to the comments in the examiner's report, then my own comments and explanation. And the idea is that this will reinforce your answer if you got it right, or it will correct your answer if you got it wrong. So were your answers right or wrong? If right, consolidate your understanding by going through the examiner's explanations. If you got the answer right, but you were simply guessing, you didn't really know why it was right, the explanation should help you to figure out why your answer was right and to understand better. If your answer was wrong, there are several possibilities. Maybe you didn't know or you didn't understand the substantive issues, and here you can learn by correcting your mistake according to the examiner's report and doing better next time. It could be that you didn't understand the question, you came to a wrong answer, in which case you can learn by understanding better. And it could be that you came to what I call an inverted answer. That is, you made the correct analysis. Let's say the claim was not novel, but you gave the wrong answer. You said true instead of false. So be very careful with inverted answers, because in the EQE, all mistakes are penalized. So it doesn't matter what type of mistake you make, all mistakes are penalized in the EQE. Good. Let's turn to the examiner's report and see what the examiners said. So they said 11.1 to 11.4 are all true. The subject matter of Claim 1 reads on a bottle having a base. And they add, the wording of Claim 1 is neither limited to comprise a liquid soap dispenser nor to comprise a tube. And they summarize by saying, hence, even the bottle of Fig 5 shown without a tube is covered by the scope of Claim 1. If we turn to the examiner's report on question 11, question 12, excuse me, what did they have to say about that? They said here, all answers are false. The bottle in accordance with Claim 1 covers just a bottle with a base, see question 11. Such bottles are disclosed in each of documents D1 to D4. And they add, any base of a bottle is suitable for touching a tube, but Claim 1 is not limited to comprise a tube. Hence, it is irrelevant if the tubes described in D1 to D4 do touch the base or not. I summarized that in my own words. The bottle's base merely has to be suitable to touch the tube, D1, D3, D4. Actual touching of the base, D2, is covered but is not required. And I add, D3's bottle is suitable for containing liquid soap. The definition of washing up liquid is similar, but in any event, the bottle is suitable for containing any liquid. Turning now to questions 11 and 12 further explanations which I add. The main difficulties stem from the interpretation of the words a bottle for a liquid soap dispenser and a base for touching a tube. And what you have to remember is that in the context of this claim, which is an apparatus or a device, the word for means suitable for, and I direct you to the guidelines F Roman 4 4.13 for further explanation, but at the same time I would like to warn you that the word for has different meanings in different contexts, so be very careful about how you interpret the word for when you are interpreting patent claims. Some further explanations. In the context of the designation of the subject matter of the claim, and here the designation is a bottle for a liquid soap dispenser, the liquid soap dispenser and its tube, which are technical terms and can constitute technical features themselves, are not technical features of the designated subject matter, which is the bottle. And for this proposition, I would direct you to Rule 43.1 EPC, which specifies that the claims shall define the matter for which protection is sought in terms of the technical features of the invention, that is, the invention as set out in the designation of the claim at the beginning of the claim. Further explanation is that these two questions, questions 11 and 12, illustrate or provide a glimpse at two facets of claim scope. First facet of claim scope is to include the invention to be protected, which we saw for question 11, which was successfully done for question 11. And a second facet of the claim scope is to exclude the prior art, which we saw was not successfully done for claim 12, because the claims did not exclude the prior art, therefore lacked novelty, therefore the claims were not patentable. Let's turn now to question 13. Question 13 introduces a new claim, which is claim 2, and we'll read together claim 2. Soap dispenser comprising a hand pump, a bottle containing a liquid, for example liquid soap, and a tube, wherein at least a portion of the tube extends along the base of the bottle. And the four questions that you're asked to answer in the immediate are: 13.1, the liquid soap dispenser of the first embodiment of the application is covered by the scope of claim 2. 13.2, the subject matter of claim 2 is limited to a soap dispenser containing a liquid. 13.3, the subject matter of claim 2 is novel with respect to D2, and 13.4, the subject matter of claim 2 is novel with respect to D4. Let's take each statement for claim 2 in turn. So here we have figure 1 of the first embodiment of the invention, and the statement is: the liquid soap dispenser of the first embodiment of the application is covered by the scope of claim 2. So here we have to compare figure 1 shows a liquid soap dispenser, or a soap dispenser, that comprises a hand pump 12, a bottle 11 containing liquid soap, and a tube 14. An end portion 14A of the tube is bent at right angles and extends along a part of the bottle's base. What do you decide? Is it true that this embodiment is covered by the scope of Claim 1, or is it false? Make up your mind, and we will go to the next question. 13.2, we have the same Claim 2, and now we have to decide whether the subject matter of Claim 2 is limited to a soap dispenser containing a liquid. So the claim says the bottle contains a liquid, for example, liquid soap. That does not limit the claim. But the question is the claim limited to a soap dispenser containing a liquid, or would it also cover a dispenser without a liquid? What do you decide? Make up your mind. The statement is true or false, and we will go to the next question. (13.3). Now we're concerned with the novelty of Claim 2 with respect to the prior art D2, and for this we have to ascertain whether the D2 falls within the scope of the claim. D2 soap dispenser comprises a hand pump 220, a bottle 210 containing liquid soap, figure and description, and a tube 240. The end portion of the tube 240 touches the base of the bottle as is shown in the figure, but does it extend along the base of the bottle? Is the claim novel, true, or is the claim not novel, false? Make your answer, and we'll go to the next question. 13.4. Here we're concerned with the subject matter of Claim 2, is whether it's novel with respect to D4, and D4's drawing is shown in the slide. So D4's system is a soap dispenser. It's part of a soap dispensing system. It does comprise a hand pump 420, and it does comprise a bottle 410 containing a liquid, which is namely liquid soap, and it does comprise a tube 430, and an end portion of the tube extends towards the base, and the tube has a horizontal portion which extends above and along the base. So you have to make up your mind whether Claim 2 is novel over D4, true or false, and then we will go to the examiner's answers for question 12. So here are the answers. I can guarantee you that they're correct. The caption I have added: 13.1 is true, the first embodiment is in the scope of Claim 1. 13.2 is true, the Claim 2 is limited to containing a liquid. 13.3 is false, Claim 2 is not novel with respect to D2. And 13.4 is true, Claim 2 is novel with respect to D4. Let's turn to the examiner's report with their comments. So the examiners say, the subject matter of Claim 2 reads on a liquid soap dispenser with a portion of the tube touching the base of the bottle as in the first embodiment. statement 13.1 and as in D2 statement 13.3. The bottle is defined to contain a liquid such as a liquid soap. Hence, the subject matter of Claim 2 is limited to contain a liquid in general. And the tube 430 of D4 is parallel to the base of the bottle, but does not extend along the base of the bottle. So there are the examiner's explanations. You have to, if you have all right, that is good. Check your answer to make sure you have the good reasoning. If you have made a mistake, check what type of mistake you have made and take the necessary remedying action compared to the explanations given. I add my own comments or further explanation on question 13. Questions 13.1 and 13.3 highlight what I consider are the time-related aspect of claims. Subject matter which is covered by the scope of a claim is regarded differently depending on its time relationship. If it's in the past, if the subject matter is in the prior art, and it discloses it's within the claim scope, the claim is not novel, and we say the claim is anticipated. If we're at the present, meaning the date of filing the patent application, if the subject matter is included in the patent application and covered by the claims, we say it is an embodiment of the invention. For the future, if a later development comes along, we call it a protected development of the patentee or the patent applicant, or a competing development or an infringement from a competitor. So when you are claiming an invention, you cover the client's disclosed embodiments, which is a present, and you generalize the claim to cover undisclosed future developments by the client or competitors, while excluding or hopefully excluding past embodiments, which are the prior art. So that is, shall we say, that is the time-related aspect of claiming. Let's turn now to the next questions. Questions 14, 15, and 16 all relate to a new claim, which is Claim 3, which we'll read through together. Claim 3 is liquid soap composition comprising 1. Water, 2. Detergent, in particular a blend of palmitate and stearate soaps, and 3. 20 to 25% by weight of glycerine based on the total weight of the liquid soap composition. Note that Claim 3 is based on the client's paragraph 10. Let's take the questions or the statements on Claim 3 in turn and then check the answers. Claim or question 14.1. The subject matter of Claim 3 is limited to a liquid soap composition comprising at least 75% by weight of water and detergent based on the total weight of the liquid soap composition. Now, the claim has liquid soap composition comprising water, detergent, 20 to 25% by weight of glycerine. So as there is 20 to 25% by weight of glycerine, there must be 75 to 80%, in other words, at least 75% of other components. And the other listed components are water and detergent. So the question is, or that you have to answer, is there at least 75% of water and detergent? What do you think the claim means? Is it true or false? Put down your answer and we go to the next question. 14.2. Here the statement that we have to ascertain is the scope of claim 3 remains the same if the expression in particular is replaced by the expression preferably. So here we're talking about a possible modification of the claim, and we're asked whether the modification will change the scope of the claim or not. Now, in particular has a different meaning or a different connotation to preferably. As these words have different meanings, does this imply that the claim will have different claim scopes? So put down your answer, true or false, and we'll come to the explanations later. Turning now to question 14.3. Here the examiners introduce a new possible claim which is related to claim 3, and the new claim reads as follows. In a soap dispenser including a hand pump, a liquid soap composition in accordance with claim 3. And the question is, would that claim be clear? Clarity, by the way, is a requirement of Article 84 EPC. Now, in my opinion is that a claim in a bottle, a liquid, means the same as a liquid in a bottle or a bottle containing a liquid, and all these seem to be clear. But the question is about, in a soap dispenser, a liquid soap composition. So you have to make up your mind whether this claim is clear or it is not clear. If it's clear, the answer is true. If it's not clear, the answer is false. And then we'll go to the next question. Statement 14.4 relates to the composition once again. It says the subject matter of claim 3 is limited to a liquid soap composition comprising at most 80% by weight of water and detergent based on the total weight of the liquid soap composition. This is a similar or a complementary question to 14.1. As there is 20 to 25% by weight of glycerine, there must be 75 to 80%, i.e. at most 80% of other components. But the question is, what is the maximum content of water and detergent? So you have to answer true or false, and we will go to the next question. This is now question 15.1, which is based on the same claim 3, and the statement 15.1 is claim 3 is novel with respect to a liquid soap composition which includes water detergent, in particular a blend of palmitate and stearate soaps, and 22% by weight of glycerine based on the total weight of the liquid soap composition. So the question is to know whether 22% by weight of glycerine is included within the scope of the range 20 to 25, and does that take away the novelty of the claim or not. So the answer will be true or false, and we'll go to the next question. So now statement 15.2, always relating to claim 3, is claim 3 is novel with respect to a liquid soap composition which includes water, detergent, in particular a blend of palmitate and stearate soaps, perfume, and 20 to 25% by weight of glycerine based on the total weight of the liquid soap composition. Now the question is, does the inclusion of the additional component perfume take the prior art composition out of the scope of the Claim 3 or not? Is the claim novel, true or false? You have to answer, and then we will check your answer later on. Question 15.3, always relating to Claim 3. Claim 3 is novel with respect to a liquid soap composition which includes water, non-ionic detergent and 20 to 25% by weight of glycerine based on the total weight of the liquid soap composition. So here the claim does not specify a non-ionic detergent, and the question is, does changing from detergent to non-ionic detergent take the prior art composition outside the scope of the claim? Is the claim novel, true or false? Make up your answer and we will check it later. 15.4, relating always to Claim 3. Claim 3 is novel with respect to a liquid soap composition which includes water, detergent, in particular a blend of palmitate and stearate soaps, and about 20% by weight of glycerine based on the total weight of the liquid soap composition. And here the question is to know, does about 20% by weight fall within the scope of the range, 20 to 25%, and is the claim novel, Claim 3 novel, true or false? Make up your answer and we will go to the next question. This takes us to question 16.1, which is still based upon Claim 3. This statement is now about amendment, a possible amendment of the application. Statement 16.1 reads, there is basis in the application as filed for amending Claim 3 to exclude from the scope of said claim compositions including non-ionic detergents. Now, to answer this question, you have to consult the description to look for a basis for non-ionic detergents and a basis of excluding non-ionic detergents. This is what we call purposeful reading that we'll discuss at the end of the tutorial. Make up your answer, true or false, and we'll go to the next question. (16.2) It would be allowable under Article 123(2) EPC to replace the expression water in Claim 3 by the expression aqueous suspension. Now, to answer this question, we also must consult the description to find out if there is a basis for aqueous suspension. So scan the description to find a basis for aqueous suspension and to see if that provides a proper basis for amending the claim. Good. You answer true or false and we go to the next question. (16.3) A claim reading liquid soap composition consisting of water, detergent and 20 to 25% by weight of glycerine has a narrower scope than that of Claim 3. So here the word comprising in the claim has been replaced by consisting, and we have to know whether the change of wording changes the scope of the claim, and at the same time you should also consider whether the change of format of the claim. Claim 3 is written in separate paragraph, subparagraph format, and statement 16.3 is written as a single sentence claim. You have to ascertain whether changing the format of the claim would also change this claim scope. Does it have a narrower claim scope if you use the word consisting, true or false? Now we come to question 16.4. The statement 16.4 is rather longer. We'll read through it together and then make some comments about it. 16.4 says, it would be allowable under Article 1232 EPC to exclude from the scope of Claim 3 compositions comprising 23% by weight of glycerine based on the total weight of the liquid soap composition, to render the subject matter of Claim 3 novel over a prior art document under Article 54.3 EPC, disclosing a liquid soap composition comprising water, detergent, and 23% by weight of glycerine, based on the total weight of the liquid soap composition. Now, you should be aware of the fact that when a question in the EQE is written like this, the chances are that it is not a new situation which has been invented by the examiners to test your ability to make legal reasoning, but it is a situation which corresponds to a decided case from the case law and where you have to apply the ratio decidendi from the case law to the situation which is given to you. Note that there is no basis in the description for a limitation to 23%. You can check that, which means that the proposed amendment would be a so-called undisclosed statement, a disclaimer, an undisclosed disclaimer. So you have to say whether the statement is true or false, and we will check then the answers from the examiners. Now, here then are the answers. We'll run down them quickly. 14.1 false, not limited to at least 75% water and detergent. 14.2 true, the scope of Claim 3 remains the same. 14.3 false, inner wording is unclear. 14.4 true, limited to at most 80% water and detergent. For question 15, 15.1 false, 22% glycerine renders Claim 3 not novel. 15.2 false, perfume is covered by Claim 3 because of the word comprising. 15.3 false, non-ionic detergent is more specific than detergent. 15.4 false, about 20% anticipates the endpoint 20%. And for question 16, 16.1 true, see client's paragraph 10. 16.2 false, disclosure of aqueous suspension in the client's description concerns D1, not the invention. 16.3 is true, consisting of is narrower than comprising. And 16.4 is true, the so-called undisclosed disclaimer over 54.3 document. Well, there are a lot of answers there. If you got all of the answers right, congratulations, but you still need to check whether you got the answers right for the correct reason. If you made some mistakes, we will consider the examiner's explanations and comments, and you can make the necessary corrections. So, what did the examiners say for question 14? They said, Liquid soap in accordance with Claim 3 may comprise other components. Claim 3 is not limited to liquid soap compositions comprising at least 75% water and detergent, since the open wording of the claim covers compositions containing further ingredients, statement 14.1, but water and detergent can be at most 80%, statement 14.4. For statement 14.2, preferably is equivalent to in particular, see the guidelines F Roman 4 4.9. And lastly, in a bottle is considered unclear, see guidelines F Roman 4 4.15, since it is ambiguous if protection is sought for the soap dispenser including the liquid soap composition or for the liquid soap composition only. Good. Now, statements, I had statements 14.1 and 14.4 are tricky because of the open wording comprising of Claim 1, which means that there can be other components in addition to water and detergent, but there are not necessarily further components. For 14.2 and the guidelines F Roman 4 4.9, the optional features, for example, and preferably have the same meaning, but just remember that these words do have different. You have to get used to the idea that words that have different meanings in ordinary context, in ordinary speech, can have the same meaning if they're in a claim or in the context of claim construction to ascertain the claim scope. And for the in a wording, just note that in a wording is unclear according to the guidelines, and it will normally always be deemed to be unclear by the European Patent Office, so you can forget the comments I made earlier about the possibility that in a wording could be clear. Turning to the examiner's report on question 15, they say all of the liquid soap compositions are within the scope of Claim 3 since they relate to more specific amounts of detergent, 22% by weight or about 20% by weight of glycerine, or more specific embodiments, additionally including a perfume or non-ionic detergents rather than any detergent, i.e. Claim 3 is not novel over any of these compositions. So 22% is more specific than 20 to 25%, and we can take the general lesson that the specific anticipates the general. About 20% anticipates the end point of the claim, 20%. The perfume question, perfume is included in the claim because of the open definition of the word comprising, allowing for the possibility of other components. And for non-ionic detergent is more specific than detergent, therefore the specific anticipates the general once again. The examiner's report now for question 16. The examiners say for statement 16.1, the last sentence of paragraph 10 of the description of the application explicitly excludes non-ionic detergents, which is the part of the description that you should have found by going through the description looking for non-ionic detergent. For statement 16.2, aqueous suspension is disclosed only in connection with the prior art discussion in the application in paragraph 2 and in paragraph 2 of D1. For statement 16.3, note consisting, which limits the liquid soap composition to the sole listed components, See guidelines F4 4.21. For statement 16.4, it is noted that the mentioned document is prior art under Article 54.3 EPC. Furthermore, no other cited document defines any value or range of glycerin in the liquid soap composition, i.e., the disclaimer does not have the effect to single out specific compositions or to render the subject matter novel or inventive over these documents. See guidelines H Roman 5 4.1. I add the comment that for the guideline F Roman 4 4.21 about consisting, this guideline does not give a comprehensive explanation of the word comprising. It merely says that if a composition is defined in terms of consisting, all of the components must add up to 100%. For 16.4, the relevant case law from the Enlarged Board of Appeal is case G103 and G203. Note that restoring novelty over a disclosure under Article 54.3 is one of the exceptional cases where an undisclosed disclaimer does not contravene Article 1232 EPC. Some further comments on these questions. We notice that the word comprising is an open definition allowing the inclusion of further components. We note that consisting is a closed definition excluding the inclusion of further components. We note that exchanging words like preferably and in particular does not change the claim scope. We note also the general maxim that the specific anticipates the general, and also that amendments must not contain subject matter which extend beyond the content of the application as filed. Let's now turn to the next questions, which are based on new claims. Here we have claims for questions 17 to 20. It's claim Roman 4.1 to 4.4. Let's read through the claims, which we'll be dealing with over the next few questions. Roman 4.1, a dispensing system comprising A, a hand pump, B, a bottle for liquid soap, C, a tube, characterized in that the bottle comprises a base which is in contact with a part of the tube. Claim Roman 4.2, a dispensing system according to claim 4.1, wherein the base of the bottle is dome-shaped for guiding away the tube from the top of the dome. Claim Roman 4.3, a dispensing system according to claim 4.1, wherein the tube has a right-angled portion and an end of the tube is in contact with the base of the bottle. And lastly, claim 4.4, a dispensing system according to claim 4.1, wherein the base of the bottle has a V-shaped well that guides an end of the tube into the lowest part of the bottle. So here are the claims for questions 17 to 20. Claim 4.1 is a general claim or a main claim, and 4.2 to 4.4 are dependent claims directed to specific embodiments, namely Figure 2, Figure 1, and Figure 3, as defined in Rule 43.3 EPC. let's take question 17 and its 4 statements first and correct, and then questions 18, 19 and 20 that are all concerned with different aspects of the problem and solution approach. Right, we have now statement 17.1. Claim 4 covers the dispensing system of the second embodiment of the application when the bottle contains hand cream instead of liquid soap. So on the slide I have illustrated figure 2, which is the second embodiment of the client's invention, and I have written in the bottle hand cream, meaning that the content of the bottle is hand cream instead of liquid soap. So we have to consider now, I think all other elements of the claim seem to be equated. We have a dispensing system comprising a hand pump 22, a bottle 21 containing a hand cream, a tube 24. The bottle comprises a base 21A, which is in contact with the part 24A of the tube. And the statement is about the meaning of the term a bottle for liquid soap. Does a bottle for liquid soap cover a bottle containing hand cream? So is figure 2 as modified by hand cream covered by claim 4.1? True or false? And we will go to the next question. The statement 17.2 concerns claim 4.2. Claim 4.2 adds the feature that the base of the bottle is dome-shaped for guiding away the tube from the top of the dome. And the question is, claim 4.2 unambiguously defines that the tube ends in the lowest part of the bottle. On the right-hand side of the slide, I have illustrated the bottom part of 3 embodiments, figure 1, figure 2, figure 3. Figure 2 is the embodiment which is covered by claim 4.2, and we can see that the end part of the tube, the base is dome-shaped for guiding the tube away from the top of the dome. That is falling under the claim, but does it define that the tube ends in the lowest part of the bottle? In figure 2, the tube does end in the lowest part of the bottle, and in figure 1, the tube does end in the lowest part of the bottle, and in figure 3, the tube does end in the lowest part of the bottle. So the drawings and the description are all consistent in that the tube always ends in the lowest part of the bottle, but the question is to know whether in fact this is unambiguously defined by claim 4.2. So you have to make up your mind that claim 4.2 it is inherent in claim 4.2 that the tube must end in the lowest part of the bottle, because that is all that is described. So what is your verdict? True or false? And we will see the examiner's comments. Next question is 17.3. This concerns again claim 4.2. And statement is, claim 4.2 covers the dispensing system of the second embodiment of the application. So we need to compare the second embodiment, which is figure 2, with the wording of the claim to find whether it's covered by the claim 4. It seems to me that it's relatively clear whether or not it is covered, and you should make up your mind whether the statement is true or false, and we will go to the next question. statement 17.4 concerns this time claim 4.3. Claim 4.3 adds the feature that the tube has a right-angled portion and an end of the tube is in contact with the base of the bottle. And the statement 17.4 is the scope of claim 4.3 is limited to an embodiment wherein the right-angled portion of the tube is positioned inside the bottle. Now we can see from figure 1, which is covered by this claim, which has a right-angled portion, we can see that the tube, the right-angled portion is right at the bottom of the bottle, and it doesn't seem to be sensible that the right-angled portion could be anywhere else. In fact, it seems to me obvious that the right-angled part must be inside the bottle. That's what is intended. But the question is claim 4.3 limited to this? You have to make up your mind and decide whether the statement is true, whether claim 4.3 is limited to an embodiment wherein the right-angled portion of the tube is positioned inside the bottle, true or false, and we'll go to the examiner's answers. So the examiners have said 17.1 is true. Claim 4.1 covers the bottle with hand cream. 17.2 is false. The position of the tube end is not specified in the claim. 17.3 is true. Claim 4.2 covers the second embodiment. And statement 17.4 is false because the right-angled portion of the tube can be outside the bottle. Let's turn to the examiner's comments. The examiners say, for 17.1, it is considered that claim 4.1 is not limited to contain a liquid soap, only that it must be suitable for it, i.e., the dispensing system may also contain hand cream. For 17.2, it is considered that the wording of the characterizing part of claim 4.1 is not limited to the end part of the tube, but may also refer to any intermediate part of the tube. The second embodiment shown in figure 2 shows all of the features defined in claim 4.2. And lastly, the right-angled portion as defined in claim 4.3 need not be the end of the tube being in contact with the base, i.e. the right-angled portion could also be positioned outside the bottle. Let's make some further comments then. For 17.2 and 17.4, note that the claim is interpreted in its broadest scope without limiting the claim to specific features of the description or drawings. For your practical work, you should note that when a claim is broader than the description, EPO examiners will interpret it broadly to introduce a novelty objection, forcing the applicant to limit claims to what is disclosed. Note also that applicants, by their wishful thinking, sometimes argue for a limited claim interpretation based on the description and drawings, but this is usually refuted. Let's go to question 18. Question 18 concerns technical effects. It's about claim 4.1 that we've seen, and it's about the characterizing portion of claim 4.1, which is that the bottle comprises a base which is in contact with a part of the tube. And the statements that we have to ascertain whether they are true or false are as follows. With respect to D1 as the closest prior art, a technical effect which is achieved by the features of the characterizing portion of Claim 4.1 is that, and now we have four possibilities. 18.1, the tube is flexible. 18.2, the tube is longer than in the prior art. 18.3, the tube cannot be straight. And 18.4, the amount of the product remaining in the base of the bottle is reduced. And on the right-hand part of the slide, we've shown D1, which is the closest prior art. Let's just do some theory before we embark on the question. Is that normally the effects or the technical effects are normally to be found in the patent application description, and in the EQE, technical effects are always found in the patent application or patent description. And the technical effects, as the question has set out, on the one hand is what is set out in the description, and on the other hand is, are these technical effects actually achieved by the features of the claim with which they are associated? In other words, a distinguishing feature of the claim, does it actually produce this technical effect? So let's go down through the four possibilities, and we'll answer them one after the other, and then we'll consider the answers in the examiner's report. First technical effect is that the tube is flexible. Is flexibility described as a technical effect? Is flexibility a feature of the tube? Second proposition is the tube is longer than in the prior art. Now, length is relative, and it's very difficult to see how the length of the tube could be related to that feature of the claim. But you answer true or false. That the tube cannot be straight. Can the tube be straight or it cannot be straight? You have to answer whether that is a possibility. And the fourth effect, the amount of the product remaining in the base of the bottle is reduced. Now, I think if you are awake, you will have noticed that this technical effect is described in the client's application. So you have to answer whether this technical effect is produced by the feature of the characterizing part of the claim, namely that the bottle comprises a base which is in contact with a part of the tube. Does that produce this technical effect? True or false, and we'll go to the examiner's answers. So, according to the examiner's report, all of these propositions are false. All of the statements are false. 18.1 is false because tube flexibility is not defined nor described. 18.2 is false because dimensions are not defined nor described. 18.3 is false because there is no implication that the tube cannot be straight. And 18.4 is false because the effect is only achieved if the end part of the tube contacts the base, which is not specified in the claim. Let's turn to the examiner's comments then. For statements 18.1 and 18.2, no technical effects can be derived from features which are undefined or unspecified in Claim 4.1. The term flexible is not defined in Claim 4.1, and the tube is not further specified to imply any flexibility. Further, Claim 4.1 does not define or specify any dimension. For statement 18.3, the fact that a part of the tube is in contact with the base does not imply that the tube cannot have straight parts. For statement 18.4, it is noted that the wording of Claim 4.1 also covers embodiments in which intermediate parts of the tube may contact the base. The technical effect of statement 18.4 is achieved, however, only when the end part of the tube is in contact with the base. Claim 4.1 does not define where the end part of the tube is positioned with respect to the base of the bottle. My comments are on the next slide. So for these four statements, they are all non-effects that are not produced by the claim feature, or for the fourth one, it is an effect that is produced but not by the claim feature. Note that for 18.4, the effect of reduced amount of liquid remaining would be achieved if the end part of the tube contacted the base, like in figure 1, 2, or 3, but this is not specified in the claim. The examiners emphasize that the effect, as set out in the description, has to be produced by the feature exactly as claimed. In the given example, the claim was out of tune with the description and drawings. In other words, the examiners have presented you with a defective claim that you had to analyze. Question 19 now concerns choice of the closest prior art, which is the first step of the problem and solution approach to assess inventive step. We can assess all of the statements separately. So the four statements of question 19 all concern choice of the closest prior art. This is the first step of the problem and solution approach for assessing inventive step. Once the claim has been settled, more than one piece of prior art is available after the search report has been issued and the claim has been acknowledged as novel over the prior art. From the EPO perspective, choosing the closest prior art is compatible with procedural economy. Question 19.1 concerns claim 4.1 again. Statement 19.1, is it true or false? Since D1, which we see the figure on the right-hand part of the slide, discloses all of the features of the pre-characterizing part of claim 4.1, D1 is the closest prior art for claim 4.1. So D1 discloses a dispensing system comprising a hand pump, a bottle for liquid soap, and a tube, and it also has a base, but the base is not in contact with a part of the tube. True or false? Is D1 the closest prior art? 19.2, this now concerns claim 4.2, which adds a feature that the base of the bottle is dome-shaped for guiding away the tube from the top of the dome. And the question, or the statement 19.2 is, since the bottle of D2 does not have a dome-shaped base, D2 is not the closest prior art for claim 4.2. D2's figure is shown on the right-hand part of the slide. Could D2 be the closest prior art despite its lack of a dome-shaped base? True or false? Then we will go to the next statement. This concerns also Claim 4.2. Statement 19.3 is, since the bottle of D3 has a dome-shaped base, D3 is the closest prior art for Claim 4.2. Now, D3 does indeed have a dome-shaped base, and the dome-shaped base is the characteristic of the feature of Claim 4.2. Does this make D3 the closest prior art? D3 seems to be different in various respects, but is it still the closest prior art? Is the statement true or false? And we'll go to the next statement. This concerns now Claim 4.3. This is question 19.4, and the statement is, since D4 discloses a tube that has a right-angled portion, D4 is the closest prior art for Claim 4.3. So Claim 4.3 specifies wherein the tube has a right-angled portion and an end of the tube is in contact with the base of the bottle. Does this make D4 the closest prior art? Is the statement true or false? Let's go to the answers for question 19. From the examiner's report, we see that 19.1 is false. The closest prior art can differ from the claim preamble. 19.2 is false. The closest prior art necessarily has a novelty distinction. 19.3, false. D3 addresses a different problem. And 19.4, false. D4 is not a promising starting point, and I put a question mark as I find the examiner's explanation a little bit peculiar. Turning to the examiner's report for question 19, what do the examiners say? A full overlap of features of the prior art with those of the preamble of the claim to be assessed is not a sufficient criterion to justify the selection of that prior art as the closest prior art. And it says, see guidelines G Roman 7 5.1. Identifying structural differences is a question of novelty, not a criterion for excluding a document as the closest prior art. For statement 19.3, D3 does not represent a promising starting point because there is no functional relation between the tube and the dome-shaped base, and the remainder of the soap is suggested to be washed out with water. And for D4, the examiners say D4 does not represent a promising starting point because the right-angled portion of the tube D4 has a completely different function, i.e. to connect the bottle being distant from the hand pump. Note that the examiners refer to guidelines G Romans 7 5.1, which list various reasons for selecting the closest prior art, but it does not discuss full overlap of the features of the prior art with the claim preamble. In other words, it sets out all of the reasons for selecting the prior art, and the claim preamble was not listed amongst the selected methods. When a two-part claim is properly drafted, the pre-characterizing clause is a general definition which covers the claimed invention in such broad terms that it also covers the closest prior art. And if during search and examination closer prior art comes in, a two-part claim has to be reformulated so the pre-characterizing clause encompasses and is based on the new closer prior art. Concerning D2, there are positive reasons why it could be considered as closest prior art. D2 has a flat base. However, D2 discloses a dispensing system comprising a hand pump, a bottle 210 for liquid soap, a tube 240. The bottle's base is in contact with a part of the tube. The base is flat and guides the tube 240 towards the side of the bottle and achieves the stated advantage of reducing the amount of residual liquid. This would justify or could justify D2 as closest prior art, despite its lack of a dome-shaped base. Concerning D3 and 19.3, D3 does not have a hand pump, and its tube 330 is spaced way apart from the bottle's base and is not arranged for the purpose of removing most liquid except by turning the bottle upside down and squeezing. This is not the same purpose as the invention, removing the traces of liquid on the bottle bottom via hand pump and with the bottle upright. As its purpose is different, D3 is not appropriate as closest prior art, despite its dome, which does not cooperate with the tube, but is for the purpose of stable standing. Further comments on D4 and 19.4. D4 discloses a dispensing system comprising a hand pump 420, a bottle 410 for liquid soap, and a tube 430. The bottle comprises a base close to but not in contact with an end part of the tube 430. The tube has a right-angled portion. To me, it seems that D4 could be adequate as closest prior art. It has the same purpose as Claim 4.3, dispensing liquid soap. The differentiating feature over D4 is contact of the tube end with the base. For this, D2 could be brought in as secondary prior art. This contrasts with the examiner's explanation. Note that the choice of closest prior art is sometimes controversial. Let's go to question 20. For this question, we have to make three assumptions. First, D2 is the closest prior art for Claim 4.4. Second, the distinguishing feature of Claim 4.4 over D2 is that D2 does not disclose that the base of the bottle has a V-shaped well that guides the end of the tube into the well. And thirdly, we are to assume that the problem solution approach is used for assessing inventive step of Claim 4.4. I have illustrated these assumptions on this slide. The V-shaped well is the distinguishing feature of Claim 4.4 over D2 as closest prior art. This is described in the client's paragraph 7. The D2 as closest prior art discloses all the features of Claim 4.4 except that it does not have a V-shaped well that guides the tube end. Question 20 now has 4 statements that we will consider in turn. 20.1. The technical problem can be formulated as how to reduce the amount of residual liquid soap. 20.2 is the technical effect of the distinguishing feature is that the remainder of the liquid soap collects in the well. 20.3, the technical problem can be formulated as how to ensure that all liquid soap is completely removed from the bottle. And 20.4 is a valid argument as to why D3 cannot be combined with D2 is that D3 does not disclose expensive liquid soaps but only washing up liquids. So for the 20.1, the technical problem, normally we will find a basis for the technical problem in the client's description, and for this we would need to look at paragraph 07 and make up our minds from this paragraph whether the problem is properly stated true or false. For 20.2, the technical effect of the distinguishing feature is also usually in the description and always in the description in EQE examples, and this can be ascertained also from paragraph 7, true or false. For 20.3, paragraph 7 says that nearly all of the liquid can be removed, but is this a proper basis for setting a problem to remove all of the liquid? That is, you have to make up your mind. And paragraph or statement 20.4 concerns a reason for not combining documents, which would be part of the last step of the problem and solution approach. And for all of these statements, I would ask you to make up your mind whether the statement is true or false. And when you've done that, we will turn to the answers from the examiner's report. The examiners say that 20.1 is true. The advantage is described in paragraph 7. 20.2 is true. The effect is described in paragraph 7. 20.3 is false because paragraph 7 does not teach complete removal. And 20.4 is false because claim 4.4 is not limited to expensive soap. Let's go to the examiner's comments. The examiners say the V-shaped well helps to collect the liquid soap into the well, and the tube guided into the well helps to extract as much amount of liquid as possible from the bottle, i.e. to reduce the amount of liquid soap remaining in the bottle. For statement 20.2, reference is made to paragraph 7 of the application, which explicitly mentions the technical effect. And the examiners go on. Paragraph 7 of the application only states that nearly all the soap can be removed from the bottle. The application does not teach a complete removal of the soap. The only document providing the solution to this problem is D3, which teaches to wash out the bottle with water. For statement 20.4, it is noted that claim 4.4 is not limited to the type of soap, and this cannot serve as a basis for a valid argument for inventive step. Here are my further comments. 20.1 and 20.2 seem okay to me, but were queried by some tutors who argued that the guiding of the tube end was part of the effect, though candidates were asked to assume that guiding of the tube was part of the claim's distinguishing feature that produced the effect. For 20.4, concerns a reason for not combining documents, which would be part of the last step of the problem and solution approach. It invites the question, is claim 4.4 limited to expensive liquid soaps? To me, the examiner's answer to statement 20.4 is correct, but the statement itself seems peculiar because D3 would not be combined as secondary prior art with D2 as closest prior art to challenge inventive step, as their theoretical combination does not lead to claim 4.4. There is no V-shaped well in the combination. The problem is to extract nearly all of the liquid. D3 solves this problem by turning the bottle upside down and squeezing, which teaches away from the inventive solution. D3 could be brought in to support inventive step, and I suppose this is what the examiners were hinting at. Let's now go through some learning outcomes from the tutorial, which first I will list and then we will go through in detail. Claim drafting theories, claim wording, ranges, problem solution, claim format, techniques, and some don'ts for the EQE. Claim drafting theories. Claim drafting is the process of defining an invention with an aim to encompass or include the matter for which protection is sought, in other words, the invention to be protected, and to leave out and exclude matter for which protection is not wanted or is not available, notably the prior art. The examiners have used the term claim scope several times, and here is a definition of claim scope. Claim scope reflects what is covered by or inside the claim definition. Anything that is not inside or covered by the claim is outside the scope of the claim. Note that the technical subject matter encompassed by the claim scope is determined by the claim wording or the terms of the claim. We saw, for instance, that question 11, or from question 11, that the main purpose of the claims is to include and thus cover the subject matter to be protected. And we saw, for instance, from question 12, that a purpose of the claim is to exclude the prior art, and claim 1 in fact failed to do this, so claim 1 would not be patentable. Several questions referred to claim scope, and that has been defined above. Now, the components of a claim, which we have seen from the examples, typically include the designation of the subject matter of the invention, for example, bottle, defining words such as comprising or consisting of, technical features of the designated subject matter. Here, for example, base is a technical feature of the bottle of claim 1, but liquid soap dispenser and tube are not technical features of the bottle of claim 1. We've noted also that technical features can be general, for example, the term detergent is a general term, or specific, for example, a blend of palmitate and stearate soaps. And we've also noticed that technical features can be limited by modifiers, for example, liquid soap, non-ionic detergent, percentage by weight, dome-shaped, V-shaped, right-angled, and so on. Modifiers are very important because they reduce the scope of the claim. Let's recap for the designation and the technical features. For claim 1, the designation was a bottle for a liquid soap dispenser, and the technical feature of the bottle was a base. For claim 2, the designation of the subject matter was a soap dispenser, and the technical features of the soap dispenser were a hand pump, a bottle, a liquid tube, and a base. For claim 3, the designation of the subject matter was a liquid soap composition, and the technical features of the composition were water, detergent, and glycerine. And for Claim 4, the designation of the subject matter was a dispensing system, and the technical features of the dispensing system were hand pump, bottle, tube, base, tube portion, and well. The components of a claim also include non-limiting statements, for example, in particular, and so on, purposive statements for a liquid soap dispenser is an example, relational statements, for example, wherein at least a portion of the tube extends along the base of the bottle, which sets out the relationship between the different technical features. Quantities and ranges, 20 to 25% by weight, for example, and mathematical equations. And neutral words that do not affect the claim scope, like characterized, the, or said, or wherein. Claim wording, we have seen some examples of claim wording, and these are the main examples we've seen in the claim analysis exercise. Comprising is used in claims to achieve an open definition. Comprising means including the following element or elements, but not excluding others. Consisting is used as a defining term in claims to achieve a closed definition that excludes further elements. The word for, in the context of a device or an apparatus, the purposive word for means suitable for. Its meaning can be described as a purposive semi-limitation. Be careful, in different contexts the word for has different meanings. In particular, and similar terms like for example and such as do not limit the scope of the claim. Ranges, as illustrated by Claim 3, claims can include numerical limitations such as ranges, e.g. 20 to 25% by weight. In open claims like Claim 3, the amounts of various components are non-defined. In closed claims consisting of, the stated components must always add up to 100%. Note also that claimed ranges cover all values between the endpoints from the point of view of protection, but do not explicitly disclose intermediate values, allowing for possible selection inventions. And for ranges, be careful to always express the percentage in terms of weight percent or mole percent, and always define what is the basis for the 100%. In the example we had, it was based on the total weight of the liquid soap composition, or as appropriate. Problem and solution has been covered by the claim analysis exercise, and first let's just revise what is a problem and solution approach and then make some comments about its application. The EPO problem solution approach is a formatted method of assessing the presence or absence of inventive step of a novel claim based on a problem solution analysis of inventions. The problem and solution approach involves the following steps: choosing the closest prior art, determining the features of the claim that distinguish over the prior art, over the closest prior art, identifying the effects or advantages provided by the distinguishing features, formulating the objective technical problem solved in going from the closest prior art to the claimed solution, and in the last step, assessing whether a skilled person starting from the closest prior art and faced with the objective problem would or would not get to the claimed solution in an obvious or a routine way. Here are a few comments about the problem and solution approach. The closest prior art, which was the subject of question 19, is very important. The choice and justification of the closest prior art is extremely important in the EQE opposition paper C, and choice of the closest prior art is something that you really must work on to perfect. Concerning the effects or the technical effects, the effects are practically always found in the patent application or patent description, and they are always found in the patent application description in the EQE, but the effect has to be tied up with the technical feature of the claim that produces it. That's what we saw from one of the last questions. The objective problem was the subject of questions 20.1 and 20.3. Note that, in my opinion, the objective problem is something subjective because it can be expressed in different manners by different people. And as there is some flexibility in the way the objective problem can be expressed, this makes it difficult for you to come to your own determination of exactly how to express your objective problem. So this is something you will always also want to work on. And the last step of inventive step of the problem solution approach is something that is going to be tested in the other papers of the EQE. A word or two about claim format. Firstly, the format of a claim does not affect its scope. Claims 1 and 2 are short, non-divided one-sentence claims. Claim 3 is written in subparagraph or so-called outline format. Claim 4 is written as a two-part claim with subparagraph formats for the preamble, and it has several dependent claims. Note that the claim format, especially dividing into subparagraphs or not, does not change the scope of the claim, and the scope of the claim does not change if you use the word characterized in that or wherein. The scope of the claim will be the same. Note that a two-part claim has a pre-characterizing part, or this is the format of a two-part claim, is that it has a pre-characterizing part that covers the invention in such generality that it covers also the closest prior art, and a characterizing part adding features that impart novelty over the closest prior art. That is how a two-part claim should be formulated. And we have noticed from the questions that if closer prior art comes in, it is going to be necessary then during the examination procedure to reformulate or reformat the two-part claim to take proper account of the new closest prior art. We have, just for completeness, the official definition of a two-part claim is in Rule 43.1a(b) EPC. Compare it with the definition that I gave above. Here are some of the techniques that we have been using to tackle these different questions. The technique of demonstrating novelty means that it's sufficient to have one difference in the claim over the prior art for the claim to be novel. We have been demonstrating lack of novelty, And for demonstrating lack of novelty, one piece of prior art must have all of the claim features of one embodiment of the claim, all in combination. So generally speaking, it is much more difficult to demonstrate lack of novelty than it is to demonstrate novelty. Purposeful reading is what we did for question 16.1 non-ionic and 16.2 aqueous suspension. That is, know what you are looking for before you begin reading. Purposeful reading is extremely important for the EQE in order to efficiently process the questions in the allotted time. Learn as you proceed, correct mistakes and misunderstandings promptly, and learn from the correction. This is what we have been doing during this exercise, and it's a pattern for all of your preparations for the exam, especially for the short legal questions, but also for the practical papers. You should always go in and do the exercise or whatever has to be done and correct it before you go on and start up a new question or a new exercise or a new paper. So it's very important to always correct before you go ahead. And I've noticed that guessing is a technique that we use. Guessing is a technique which is very much in fashion with the pre-exam of the EQE, because you give the answers without providing the legal basis for the answer, which is what is guessing. Now, all patent attorneys are involved in guessing, but as a patent attorney becomes more experienced, the base that he uses for making the guesses becomes more and more accurate. So the more accurate base that you have for your guesses, the more accurate will be your guesses. As a rule, patent attorneys who make a guess, especially if they're with a client, and they give an answer and they're guessing, when they go back to their office, they will always check what they guessed, and if necessary, take corrective action. So guessing is very important for the EQE, and we will see that in connection with the other papers. Don'ts for the EQE. Now, there are a few things that we have learned which are good from this exercise, but there are a few things from this exercise that we have learned which are bad and which you should not repeat. So do not take the claims from the pre-exam as a model for the type of claims that you should be drafting for paper A. The claims are deliberately presented as poor claims so that questions about interpretation can be raised, and they should not be taken as your model of a good claim. For example, claim 1 that we saw lacked novelty over D1 that was already prior art known to the applicant, and it was also lacking novelty over the client's own bottle of figure 5, which, though it wasn't stated that it was prior art, it was obviously also prior art. Now, when you sit the drafting paper A, if you present a claim like this, which lacks novelty over the given prior art or over common general knowledge, that is one of the most sure ways of failing the exam. A lesser point is that you should not include optional features like in claims 2 and 3 in the claims that you present for paper A. The examiners for paper A do not like this, and additionally it deprives you of the possibility of obtaining credit by presenting the feature in a dependent claim. So rule out optional features from your claims for paper A. And lastly, I say avoid juxtaposed features that are not functionally related. like the hand pumping claim 4.1, for example, if you have juxtaposed features that are not related, that leaves the claim vulnerable to losing novelty, and it leaves the claim vulnerable later also to losing inventive step. What next in your preparations for the EQE? I suggest that you repeat several claim analysis sections of the pre-exam, correcting as you go along, more or less in the fashion that we did during this tutorial. When you pass the pre-exam, however well you do, check all of the answers against the examiner's reports and make sure that you understand why you got the correct answer, or, if necessary, correct your answer if it was wrong. I suggest that you practice claim drafting on several A papers to complement your work experience. Always correct your claims before going on to the next paper. So even when you're working on claim drafting, use the same principle that you must correct your work before you advance to new subjects. For paper B, make sure the client's claim proposals are patentable and formally correct, which is Article 132 and clarity. You should also, for paper B, practice a problem solution format for the arguments in support of inventive step. And in this exercise on claim analysis, we have seen partly how problem and solution approach comes in. For paper C, practice detecting and demonstrating lack of novelty. Novelty and lack of novelty can be razor-edged, and going wrong on novelty is one of the good ways of failing the C paper. When you are reading the description of the patent to be opposed, earmark the effects associated with the claim features for developing future attacks for lack of inventive step. Just as we earmarked the effects that we were looking for the claim features in the claim analysis example, use the same principle for building up your attack for lack of inventive step. And for paper C, work on justifying the choice of the closest prior art.